Since the 1990s, it was felt that there was a need for a legal framework governing data transfers from the EU to the US to ensure that EU citizens enjoy an adequate level of protection in the US, especially regarding their personal data. So what was agreed between the EU and the US was a safe harbor framework that was agreed in 2000, and that was designed to guarantee that EU citizens' personal data are protected even though they are transferred to the US. However, the safe harbor framework didn't last in the long run because at some point it was discovered that major tech companies collaborated with the US intelligence authorities and especially the National Security Agency, the NSA, to collect and process EU citizens' personal data. This was part of the Edward Snowden's revelations in 2013, and those revelations brought into light the fact that under US law there is a specific provision, Section 702 of the Foreign Intelligence Surveillance Act, that allows the NSA to collect personal data from US tech companies. Of course, within the Section 702 framework, there is an obligation for the NSA to get an authorization on an annual basis from the Foreign Intelligence Surveillance Court. But this authorization that is given to the NSA to conduct a specific surveillance program is granted to the NSA by this court. Generally, there is no control over the targets of the surveillance exercised by the NSA, which is really problematic. This is part of the reasons why the Safe Harbor framework was annulled by the European Court of Justice on the basis that the guarantees provided by this framework were not sufficient in the light of the existence of Section 702.
Sciences Po.